Okay, concerns about the other party. This is basically a summary of testimony exhibit. So in almost every family law case where we're talking about custody, they have concerns about the other parent. And their concerns may be they drink too much, they're working all the time, they're not available to the children, they're too harsh of a disciplinarian, they're not harsh enough as a disciplinarian, they're feeding the child junk food, whatever the list is, that are their great concerns of why. And usually this is because we're asking for a change in custody, or we're trying to keep from the custody being changed. And it's helpful to your client to prepare this exhibit, because on the stand they're nervous and they can't always remember everything that they meant to say. And in fact, a funny phenomenon is the biggest thing, like maybe the big thing is the other side is mentally ill, or the other side is an alcoholic. Then you ask them on the stand, what are your concerns about the other parent? They skip that one and they start talking about weird stuff, more the minor stuff. Oh, they don't brush her hair or whatever. And I'm thinking to myself, alcoholic. And I think sometimes the biggest thing they've thought about so much, it's just taken for granted that everybody knows that's their concern. So on your concerns list, this would be a bullet point list of the concerns, and it would have, of course, the biggest concern first, and it would never be more than one page. Bullet point using incomplete sentences, as few words as possible, so it's easy to read. And this is a way to prepare your client, because you and your client are now having a conversation about what are your concerns. They're looking at the list. They have an opportunity to say, no, I'm really concerned, that he doesn't walk the dog. And then you can say, I hear you. That's really not a concern this court's going to care about. So you can clear out those issues with the client ahead of time, and they can have time to think and not be on the spot in the hearing. So that's one reason to prepare it. The other is that they're going to have it in front of them while they're testifying, so they don't have this crazy forgetting, because it's right there. And if the judge takes it under advisement, so sometimes the judge doesn't rule on the spot. They have another hearing right after yours. They don't have time to rule on the spot. They want to think about something. They want to read the law. They want to reread the pleadings. You would love, if you got that into evidence, your list, now they have your testimony in written form, basically, because they have that list of concerns. And very few lawyers do this, so they're not likely to have the competing lawyers list. So now you have an advantage, because the judge has taken that into chambers, and they're going to be like, oh yeah, he's an alcoholic, he doesn't walk the dog. No, you're not going to have the dog on there. But you get the idea. So that's a very important reason to do that. So you'd almost always have that, assuming this is the type of case.